We're now going to move on chronologically a little bit to the broad sort of development theme. So you've assessed your title, you've worked out if there are rights of light, you've got your settlement fund, you've looked at your covenants, and you've worked out whether you need a 84.2 application or to modify. And the development phase is underway. And we all know that the development phase itself doesn't go as smoothly as might always be wished. And a couple of roadblocks to that development, which we're going to hear about now, are insolvency, and also particularly perhaps if you're building offices for a petrochemical company or something like that in this modern age, imposters coming on where injunctions might be needed. So without further ado, I'll hand over to Jennifer, who's going to speak about insolvency issues.
We're going to talk about a fictional development called Serle Square. It's an undeveloped block. So what's happened is there's been a development of a 7-story block, which failed. And now we're going to also develop a 17-story block joined onto it. So there's already a building in place. We're going to sort of partly demolish that and then build this taller building attached to it. The freehold is held by New Square Land. There's a 999-year lease of the whole site granted in the 60s, and Serle Developments owns that now. They have granted a development lease to Intrepid Investments, and Intrepid have in turn entered into 100 agreements for lease with investors who've paid 50% of the premium on exchange. This is going to be buy-to-let properties, or it's going to be student accommodation. Now, before I move on to considering the insolvency aspects, just to flag a little hobby horse of mine, this last element of our facts is often referred to as fractional investment schemes. I am yet to see a fractional investment scheme that isn't a collective investment scheme as defined by the Financial Services and Markets Act 2000. And if it is a collective investment scheme, then unless the people running it are regulated by the FCA, they're committing criminal offences. And even if they are regulated, it can only be advertised to certain people. And this type of investment scheme is only ever going to be an unregulated collective investment scheme. So if you ever see the words fractional investments, just remember that and think about it a little bit further. I'm sure you all know that anyway. But we're not talking about that today. We're talking about what happens if the developer goes bust, the developer here being Intrepid Investments. Our scenario is that the work starts on this taller tower, but Intrepid Investments falls into administration and the work comes to a halt. The right to forfeit has arisen due to the entry into formal insolvency process, and Serle Developments has served a Section 146 notice and wants to get back possession. I think for our purposes, we'll assume that there's either been an out-of-court appointment by the directors or there's been a court order placing the company into administration. I'm not dealing a huge amount with lenders, but obviously it's far more likely that a lender has in fact put the company into administration. So what's the effect of administration? Now, Section 43 of Schedule B1 to the Insolvency Act, as you'll all know, Schedule B1 has everything about administration and has done since the Enterprise Act 2002. Paragraph 43 provides that the landlord may not exercise the right of forfeiture by peaceable re-entry or institute or continue legal proceedings, including forfeiture proceedings, without the consent of the administrators or the permission of the court. I'll come on to permission, but it's always worth bearing in mind that consent is also a possibility. In another context, a client of mine recently agreed with administrators that the company in administration ought to be included as a defendant to proceedings. We didn't have to make an application for permission because it was done by consent. If the lease is of no value to the administrators, they there may be some reason why they're not willing to surrender it, but they may be happy to consent to you starting proceedings. Another option, which I'm sure you've all come across, is administrators quite like to not object to things. So it may be that they won't consent, but if you make an application, they won't object to that application. All entirely depends on the particular facts. So in our case, they're not going to consent. And so an application for permission is necessary. For Serle Developments to make out its case, you need to establish that there are two questions for the court. Would forfeiture impede the purpose of administration? If not, permission will normally be granted. And second, would it be just and fair balancing the respective interests of Serle Developments and the creditors of Intrepid Investment? It's worth bearing in mind that the burden falls on the applicant. So the burden falls on Serle to establish that it ought to have permission. It's not for the company to prove that permission shouldn't be granted. Would forfeiture impede the purpose of administration? Well, the statutory purpose of administration is threefold. It is to rescue the company as a going concern. If that isn't possible, to get a better result for the creditors as a whole than would be possible in a liquidation. Or the third of those priorities is to realise property to make a distribution to preferential or secured creditors. Now, pausing there, there's a potential slight hole in our factual scenario. Why would this company be in administration if all it's got is this failed development? I suppose we assume that this is a bad development. There are other better developments also in the company, and that's why administration rather than liquidation has been possible, and why the administrators are willing to take the appointment perhaps more pertinently. The balancing exercise that the court needs to go through, there's a wide discretion, and I'll come on in a moment to show that to mention two cases where the opposite decision was made by the court. But obviously it's a discretion which needs to be exercised judicially. What are the legitimate interests of Serle Developments? Now that depends on all sorts of facts that I haven't told you. So whether there's any rent due, whether there's any rent that might become due in the future which they know that the administrators can't pay, whether they have people lined up to take a new lease of the development if this one is forfeit. The next question is, what are the legitimate interests of Intrepid Investments creditors? That's obviously to be paid. What is going to be of interest to the court there is valuation evidence, evidence that there will in fact be payments to the creditors if the lease is not forfeit. So in an incredibly rare situation, it might be that you're going to have a trading administration where the administrators themselves develop the property and continue to build. I've not seen it done, but I'm sure it's certainly possible. You might have a situation where the administrators are intending to sell the lease. You need to make sure there that your expert evidence is on point and you're very clear on what the agreement is or what the agreement might be from the potential buyer and what they're paying for. Because it's only if a substantial amount of the money payable is referable to the lease that the court is interested. If in fact what they're paying for is the IP, the business of the company and so on, then they're going to be less interested in that. And if you're assisting your transactional colleagues, that's something to bear in mind. If there's been for some tax reason, there's been a decision to not allocate very much value to the lease and more value to the other stuff, that may cause problems. The treatment of proprietary interests is important. The court is very interested in the fact that the landlord obviously has a proprietary interest in the property, but has an entitlement to forfeit. And also relevant is the conduct of the administration. So actually, if your administrators haven't really taken any steps to market this lease, or have been dilatory in that, or look like they're selling it to connected parties without doing the proper pre-pack, taking the proper pre-pack steps, then that's something that the court's going to bear in mind when determining whether permission ought to be granted. The key cases here are SSLR realisations in 2015, Atlantic Computer Systems and Sunbury Properties. I'm going to talk about the first and last of those because Atlantic Computer Systems isn't actually a property case. It's just the Court of Appeal case that establishes the criteria that the court applies. So SSLR realisations was about a Strada restaurant in the Brunswick Centre, not very far away from here. The administrators wanted to assign the lease, and the landlord wanted to forfeit. All sorts of things came into play. It wasn't clear that the administrators had done the proper job in terms of exposing it to the market. But a huge amount of, so I ought to say that permission was given to forfeit. A huge amount of the discussion in there was about the structure of the deal. And in fact, although $1 million was said to be what was being paid for the lease, that in fact wasn't right. And it was being divvied up in a way that was different from the way that the administrators wanted the agreement to be read. What the administrators had as a fallback was evidence of market value on the open market, not as part of the essentially pre-packed deal. And again, that evidence was insufficient, not least because the potential buyer that they had, Wagamama, was only willing to pay for the lease if they got a seating license for an area outside of the demised premises, which Strada had, but which was entirely within the gift of the landlord, was a personal right, and the landlord wasn't willing to give that seating license, unsurprisingly, to Wagamama, and therefore that value wasn't a correct, wasn't the correct value, wasn't a true value of the lease. Also important in this case and in others was the fact that when you're looking at assignment, you need to consider the circumstances in which the landlord can refuse permission to assign the lease. And if they have an absolute right to refuse permission, and they say that they're going to refuse permission, then there is in fact no value, no realisable value in that lease for the company and administration. So that was SSLR. And I think that really is, if you're looking at this kind of situation, that is an instructive case because there are all sorts of things that were argued there. In Sunbury Properties Limited, permission wasn't given to start proceedings to forfeit. And the reason that this was a different type of premises, it was a premises that held frozen food, millions of pounds worth of frozen food. And the company and administration had given a license to another company to occupy in breach of the terms of the lease in order to distribute that frozen food to the customers. And the only real downside for the landlord, because it was a temporary situation, they just granted that license until they dealt with all the frozen food. The only real downside for the landlord was that under the terms of the lease, rent was payable quarterly in advance, whereas the administrators were going to be paying rent monthly in arrears. And that was the real difference between the two. And the court wasn't satisfied that the prejudice to the landlord was sufficient there to interrupt the fact that it was in the, it was for the purposes of the administration, it was it was going to help realise assets for the benefit of the creditors of the company there. And so forfeiture wasn't possible in those circumstances. We've got the slight complication here of our fractional investment scheme. Do those investors who've paid their 50% interest have a proprietary interest? And does that prevent Serle Developments from granting a new development lease if it successfully forfeits? Now, as to the first question, that really depends what the agreement says about where the asset is, where the apartment is that particular investor is going to be given a lease of at the end of the day. If it's in our 7-story block that is built and isn't going to be wholly demolished, is going to be partly demolished to build this higher one, then they'll have an equitable lease, Walsh and Lonsdale. Pretty straightforward, although actually there can be complications as to whether that equitable lease is founded upon the right to specific performance. If there are conditions in the agreement for lease which mean that you wouldn't be entitled to specific performance, it's arguable you don't have an equitable lease. That's can be complicated and interesting, and there was a case, Val Boney last year about that before Master Brightwell. But what about those people whose agreement for lease relates to this 17-story building which hasn't been built yet? Well, what Eason and Wong says is that they have a lien. And they have a lien that attaches to the relevant airspace that would be occupied by the building once built. So they do have a proprietary interest. And so that may be of relevance. What I haven't dealt with here is whether they've got UN1s. Obviously, that's fundamental to whether they actually have anything of value. Now, if they do forfeit, they all fall away. So this is only relevant if you're looking at a deal being done between the administrators and the landlord. But what Schedule B1 paragraph 71 provides is that a landlord an administrator can apply to the court to sell property as though it were unencumbered. So property where there are charges registered against it, or as here there are equitable leases or liens, can apply to the court to sell with unencumbered, although the money that it receives has to be used to pay those individuals wherever they fall in the waterfall of secured interests. I'm not going to deal with that in a great deal of detail. Those are two of the cases in which it is dealt with. Again, the court's going to be interested in whether this furthers the purpose of the administration, which is always going to come down to valuation evidence and evidence of real intended purchasers. It's always going to come down to money, who's in the money, who's out of the money. But paragraph 71, if you don't know about it already, which you may well do, is well worth knowing about in that deal between the landlord and the insolvent developer. Now, what often happens in these situations is it's all dealt with before the company goes into administration. Everything's dealt with by way of a watertight pre-pack that's been tested by the pre-pack pool. Everybody's happy with it. And it's clearly in the interests of the creditors as a whole, and so on and so forth. That isn't the case here. And often isn't the case, really. They're both common scenarios. And so what we're assuming here is that there's a hiatus where the landlord and the administrators are trying to do a deal about what on earth is going to happen with this development. Someone is going to need funding to continue the development, and that takes time to sort out. And so we have this building site with cranes and other plant on it, with a building which is there and a building which is yet to be there. And that is a ripe situation for urban explorers. And that's what Matthew and Michael are going to talk about, we haven't mentioned this isn't a petrochemical company. So we're not looking at protesters here. We're looking at urban explorers and other trespassers. But this is a situation in which they may well take advantage of the relatively empty site and try to get on and try to make trouble and content.
Yeah, well, thanks, Jennifer. I mean, so in our scenario, we're not looking at a situation where we've got protesters, but you might well have a situation where you've got protesters on your client's land. And similar principles will apply, but there's probably an extra layer of human rights considerations, which we haven't got time to go into today, but it's something you need to be aware of. So what we're really focusing on is urban explorers. And I can tell you through experience that building sites are a playground for social media content creators. And I've done a number of cases over the years. I did a crane climber case many years ago now. It was before the cases we're about to talk to you about. But we had this individual who's climbing to the top, the very top. I'm talking the jib tip, completely unsecured and not held on by ropes. It would have been good night if he'd fallen. And my clients instructed, who were the developers, instructed me to go and get an injunction. And it turned out on the return day, he was actually a minor. So he wasn't even 18. He was a few weeks off his birthday. And we were tipped off to this by his mum, who wrote to my instructing solicitors and said, look, he's got a very big inheritance coming from his late granny. And I'd very much like you to take it off him by way of a costs order, because I don't want him going around the world doing this. He'll end up dead. So we did. We took his inheritance by way of a costs order. Anyway, I digress. Now, as many of you all know, the law of injunctions has seen huge developments in recent years, principally by two decisions of the Privy Council and the Supreme Court, respectively, in Broad Idea International Limited and Convoy Collateral Limited. And then in the case we're going to talk about, which is Wolverhampton City Council and London Gypsy and Travellers. It's that second case that forms the basis of our discussion on newcomer injunctions. So Wolverhampton concerned a series of injunctions obtained by local authorities or groups of local authorities to prevent gypsies and travellers from camping on local authority land without permission. And the injunctions were addressed to persons unknown. They were often borough-wide. They were obtained without notice to the travellers themselves, and they obviously therefore weren't represented. Now, there's no need for us in this discussion to chart the procedural history of that case, but the key point to draw out from Wolverhampton is that the decision has much wider application than just to public authorities or to gypsies or travellers. It's primarily focused on that, but the Supreme Court has laid down guidance for wider application, and it set down guidance on how and when claimants should seek an injunction against persons unknown and unknowable at the time of the application. So the key thing to bear in mind is that it is a brand new injunction. It's a new species of injunction, much like the Morava injunction was created in the 1970s, or the ability to make internet blocking orders was recognized about 10, 15 years ago in the 20th Century Fox case. The Supreme Court in this case in Wolverhampton recognized an entirely new category called newcomer injunction. And it's just, before I go on to some of the features of it, worth bearing in mind that newcomer injunctions doesn't just apply to real estate, doesn't just apply to land. It will have potentially much wider application. And to give a very small shout out to my colleague, Mark Delahante, who is very innovative. He managed to get the commercial court to grant a newcomer injunction in a case called Williams and Nest Services recently, where he got the court to order that it was a crypto case, that anybody into whose hands the crypto came, they could just pitch up and say, there's an injunction, give us the information about where that came from, without the need to go back to court. So an innovative use of the newcomer injunction jurisdiction in a context that's not related to real estate. Whether or not that's legitimate or not, we'll see. I know you got lots of disobliging comments on LinkedIn when you put it up, but there we go. So, before we go on to what it's all about, let me tell you about a recent case I did just a couple of months ago. This is Spitbank Fort, which is one of 4 forts you'll see dotted around the Solent. And this one was completed in 1878. It was designed and constructed to deter the invasion that was threatened by France, and that's long since passed by the time it was actually finished, which is why they're called Palmerston's Follies, in name of Lord Palmerston. So over the years, it's been used by the MOD. It was then a hotel until about 5 years ago when it had to close because of COVID. Now, since it closed, it's received regular unwanted attention from urban explorers because it's not occupied, it's very dangerous, and people like to go out there and explore it, film it, put it on social media. They always cut out the bit where they break the locks, but a point we made to the High Court when we saw our injunction. But that's a case that I did recently, and one of the I'll talk a bit about it a bit more when I talk about the characteristics of the injunction, but this was a typical case where you need a newcomer injunction because you've got no idea who's going to, in the future, try to trespass on it. So I'll come back to it. But in our case, in our scenario, you'll want a newcomer injunction in respect of the building site where you might have crane climbers or, as Jennifer said, one half of the building is derelict. People like exploring derelict old buildings. You go onto YouTube, you could be sucked into hours of footage of this, as I was in the preparation for my recent case, and not much got done whilst I was watching all these fascinating exploration videos. So the characteristics, there's no distinction between interim and final relief with newcomer injunctions. There's a little bit of discussion in some of the recent cases on it following Wolverhampton. It's all wrong. There is no distinction. So any case that you read from the High Court in the last year or so that says there is a distinction, you need to apply for summary judgment, it's rubbish. So you can seek final relief at the first hearing, as I did at the Spitbank hearing. Now, the court can say you're coming back, there'll be a return date, but there's no requirement for it. So that's one of the first characteristics about newcomer injunctions that makes them very different from interim relief that you would seek. So you'll often seek that final injunction. I might come back to that in a bit more detail if I have time. They are made against people who are unknown and truly unknowable at the time of grant, and potentially apply to anyone in the world. The contramundum order, it's the purest form of a contramundum order because it binds everybody. One of the factors that came out of the Supreme Court decision, because before the Supreme Court decided that, they weren't quite sure. It's, did you breach it? Did you have to breach it to become a defendant? The Supreme Court said no, it binds everybody with notice of it. And we'll come back to how you give people notice in a moment. So it is very wide in its scope, potentially. They are always made without notice, although you can advertise before or after you seek your injunction. We in Spitbank tried to tip off the press to tell them about it, but then factors might come to bear on your particular case. It did slightly on Spitbank. We didn't want to tip off urban explorers we were going to do it because they might think, well, I'll get down there tomorrow then, or this evening, do my footage before I'm bound by a High Court order. And that might well apply in our scenario here. If you've got an empty site where you've got a crane and someone thinks, well, I don't want to be in contempt, I'll do it tonight. So you've got to think about those sorts of things. While the injunction is always discretionary, there is generally unlikely to be a real dispute to be resolved or a triable issue as to the claimant's entitlement to the injunction. So thereby distinguishing it from the test for an interim injunction under the American cyanamide test. Now, the injunction is sought for its medium to long-term effect rather than as a means of holding the rein as you would with ordinary interim relief. And so that, again, is one of the really key factors that distinguishes it from other categories of interim or final relief. And it's designed to provide a more effective, possibly the only effective means of vindication or protection of relevant rights. And that's particularly important, for example, where you've got an open site like ours in our scenario, where it's very difficult to police the border, or a fort in the middle of the sea, where you can't just keep people out. You can put CCTV up, you can put signs up saying keep out, but really motivated people will go there anyway. And so these types of injunctions are designed to stop those individuals, make them think twice. And as I said earlier on, it's inherently an order that has effect contra mundum against the world. So what do you need? There are substantive requirements and procedural requirements. Matthew's going to talk a bit about the practical elements of it and the procedural elements. So I'll just go through the substantive requirements. This is set out at paragraph 167 of Wolverhampton. If you've got spare 5 hours, you can read the 90-page decision yourself. It lays down 5 conditions that have got to be satisfied before the injunction will be granted, and that's a compelling need. So you must sufficiently demonstrate that by evidence, and you've got to demonstrate that you can't adequately meet the deterrent effect in another way. So I just mentioned there that CCTV might be putting extra guards on your building site, something like that. You've got to show you've done all those things, you've tried them, it's failed. And in Spitbank, it was quite easy to make this out. The property was unoccupied. It was in need of repair. It had a range of hidden dangers. It was probably more dangerous than a normal construction site on terra firma. The property was also in shallow waters. So if you took a vessel that was inappropriate out there, you could run aground. But conversely, people were paddleboarding out there, which was really dangerous as well. So they could be swept out to sea or collide with other ships or other vessels. There was no electricity. The generator was unreliable. I mean, I think the judge was bored with the dangerous factors in this case by the time I reached the end. There was Legionella, etc., etc. The second is that procedural protections are required. As I said, Matthew's going to talk a bit more about that, but you've got to take all reasonable steps to draw that application to the attention of those that are likely to be affected by it, and it has to contain generous liberty to apply provisions. Now, this is normally dealt with by way of a notice. So following the hearing, you put a notice up at prominent places. We did it at marinas or on beaches. If you go into a Shell garage and you're filling up your car, have a look up at the pump, and there's a notice there warning you that that forecourt's protected by a High Court injunction. So there's lots of examples of protester injunctions where you will find those notices warning you that premises are protected by an injunction. So the next requirement is that you've got to give full and frank disclosure. I don't need to tell you it's vitally important. In any without notice injunction, you've got to take great care to observe that duty. Matthew, do you want to tell us a little bit about what we should be thinking about?
Yes, it's a scary one because the test for it is not very helpfully defined, except to say, more or less, if you think it might be worth saying, you have to say it. It covers everything that's material to both the cause of action, to the procedure you've followed, to things like how you've obtained evidence, whether you've delayed, or any other thing that has cropped up in your mind while worrying about it. And it covers things that you don't know yet. I was thinking about insolvency practitioners, if they need to go and get an injunction, or an IP who's been parachuted in probably doesn't know very much about what's been going on. But there is a duty to make reasonable inquiries. What's a reasonable inquiry? It depends. But it could involve something quite onerous, going through all the data you have available, going through historic email accounts, asking people who will answer questions what has been going on. And it's a continuing duty, which extends through to and beyond the hearing. If you have to put in a supplemental witness statement, that might be a sensible way to deal with it if you can. But it may be that things are happening in an evolving situation so late that the only way to deal with it is for counsel to deal with it on their feet.
Yeah, and when I'm on my feet dealing with these sorts of without notice injunctions, I'm very clear. I'm now going to set out the argument against me for the grant of this injunction, and the reasons that, if they were here, a potential defendant would give as to why it should not be granted. The next factor is territorial and temporal limitations. In our own example, it's a building site, and so it's quite easy to think about what are the territorial limitations you wanted just to apply to that building site, but it shouldn't apply to the surrounding area unless it's absolutely necessary. I think it was the Canada Goose case, which involved protesters outside the shops of Canada Goose, where there was quite an argument over the extent of the territorial limitation of the injunction, because if they are the proprietors of a shop that extends really just to the perimeter of the shop, that isn't necessarily an appropriate territorial limitation, because someone's just going to stand at the doorway scaring off those that want to spend £2,000 on a coat. So that's very important for you to bear in mind. Temporal limitations mean that you need to think about how long your injunction is going to last. In Spitbank, I got the court to grant an injunction for 5 years with annual reviews, and that's reasonably common. If you look at all the cases, they in the private property sphere tend to be between 3 and 5 years, and it will depend on the factors. But I persuaded the judge that 5 years was appropriate with those annual reviews. If you're for a local authority and looking at cases involving travellers, 1 year is what the Supreme Court says is the appropriate limit, and it can't extend to the whole borough. It's got to be tightly drawn, and so if you're dealing with a case where the territorial limitations are going to be tricky, you've got to really give some consideration to how you're going to justify this to the High Court. And then the just and convenient test, this is the test we all know very well, and so I won't go into it in any more detail. So, as the Supreme Court said in Wolverhampton, the lower courts are going to develop this injunction as it applies outside of the ambit of, say, travellers and local authorities. And indeed, they have done that. It's expressly anticipated by the Supreme Court. The subject matter of these cases is quite wide-ranging. It includes airports, building sites, universities. There's a case involving Epsom Racecourse, which deals with Derby and protesters that they were concerned about. And then there's a case called Valero Energy and Persons Unknown. That was one of the first newcomer injunctions heard after Wolverhampton. Mr. Justice Ritchie added other requirements to those laid down by the Supreme Court, paragraphs 57 to 60 of his judgment, and he gave 15 additional requirements. And they included the need for a cause of action, damages not being an adequate remedy, but many others. This has been applied in lots of cases since, protest cases such as Cambridge University and Persons Unknown. I don't have time to get into it, but I think that he's wrong. I think that case is wrong. I don't think that there are 15 additional requirements that can be derived from Canada Goose, as he says. I argued that before the court in Spitbank, but it was an interim final injunction. The judge wasn't prepared to get into it, but in an important case, it's worth bearing in mind. It's not to say that all 15 factors are wrong, but I think there are some of them in there that are just plain wrong and can't be reconciled with authority. So I'll just get off my hobby horse and turn to Matthew. Matthew, can you give us some practical guidance for preparing for injunctions?
Thanks, Michael. I mean, a lot of this will be extremely familiar, but given the stress and the coffee that accompanies most applications for injunctions, I thought it might be helpful to put together in one place the kind of things you might be thinking of at the beginning of injunction day all the way through to the end of, or possibly the next morning. I'm trying to get in the head of those who have to draft these applications. So, first thing to think about is how to notify the defendants, as Michael said. It's good to start thinking about this at the beginning of the process, even though as your thinking evolves, as you start thinking, for example, about how you're going to identify the defendants, the answer you get to in terms of what is a reasonable way to notify them, that might evolve. But if you haven't started thinking about it from the beginning, it's going to be quite difficult at the end of the process when you need to go and do that notification to come up with it in a timely way. So the obligation is to use all reasonable attempts to contact potential defendants. As Michael said, there might be good reasons why doing something that is apparently obvious, that might not be reasonable if it's going to undermine or something else or create some other risk. But equally, it's important to do everything reasonable. So it's not an obligation to underplay. And then you want to think about how you're going to prepare the evidence. I think it's certainly my experience now that judges are starting to prefer factual witness statements to be given by lay parties rather than by solicitors. Obviously, I think that's a general approach. There might be circumstances in which there is genuinely no time to prepare a witness statement for a lay party, or if, and I can't really imagine how this would apply with this type of newcomer injunction, but there might be circumstances in which the points being made are so legal and so little and so little factual content that a solicitor witness statement might be appropriate. But in general, I think it's good to get a lay party. That, of course, requires you to think about who the best witness is going to be. If you have a client who's a large organisation, you might want to think about who is there on the ground, who is closest to the factual detail. Obviously, you can include hearsay, and it's probably sensible to include that. But particularly when you take it in parallel with the duty of full and frank disclosure, it's really important to be precise about where they're getting their information from and how reliable it is. And anything that might undermine the quality of the witness's own evidence will fall squarely in the duty of full and frank disclosure. So it's important that the witness statement includes that. And just as Michael said about dealing with this in submissions, it's also helpful for the witness statement or affidavit to have a separate section called full and frank disclosure, where if in doubt, you chuck everything potentially relevant in. So it's all there in one place. Something else to think about when putting in, it might seem obvious to put in details of the property and the potential risk or consequence if the order is not granted. But sometimes things that are so obvious can be omitted. And it's helpful to remember the position of the judge who hasn't been there, who hasn't seen this place, who doesn't necessarily know about the risks of Legionella that you might get from trespassing in a Napoleonic sea fort. So it's really helpful to spell that all out, get the judge in the headspace, so that they can really understand what the problem is. And then there's the question of full and frank disclosure, which I've talked about already. So another thing to think about is who's going on the claim form as parties. Obviously, in these cases, you don't know who the defendants are, but you might know specific individuals. So if it's a Extinction Rebellion type case, or that's a protest scenario we're not thinking about, you might know the names of the organisers. And if you do know them, then it's good to put them on the claim form. But if you can't identify them, and you won't be able to identify all of them, here are some things to think about. First, being really clear about who is and is not included. Second, you can identify a class, but if you're going to do that, that description needs to be sufficiently clear. And third, if you're going to identify people based on acts they perform, it's important not to identify legal conclusions. So saying trespass is inviting a legal conclusion. But if you say people who enter onto the land without permission, you're putting two facts together, which together can get you to a legal conclusion. And the idea is that it's to help people who are looking at this notice identify, without being lawyers, whether they do or do not fall into a certain category. And if you look at the lists of parties in a lot of the cases, it will run well past a page. There might be several different categories. You can have 8 or 9 categories, one for each type of act or for each class of people. So it can take some serious time to think about and then write out a good form of wording to identify the defendants. And I think it's,
in our scenario, it might be persons unknown entering or attempting to enter Serle Square without the written consent of. But that's a very simple example. As Matthew says, often it's much more complex. You've got to really think about it.
So next, the draft order. Lots of things to think about. First, do you need a penal notice? If you're going to want to think about committal proceedings, that's going to be essential, but it is for the party to think about and then do. It's not the court's decision. And in terms of committal, the court might be concerned to ensure a higher level of procedural protection for the defendants. And that might involve adding a permission requirement before committal proceedings can be initiated. But that's not invariably going to be the case. And indeed, in the recent London City Airport decision of Mr. Justice Bourne from last month, that wasn't required. Next, think about how you define the prohibited actions. This needs to be clear and easy to follow. We want to avoid Latin, archaic language. It needs to be simple, one syllable words if you can. If it's drafted vaguely, you might be able to fix that in the hearing, but that's really not an ideal situation if it's something that can be avoided by preparing early. And there is a risk that if you turn up with an unclear draft order, it just sets you off on the wrong foot with the judge. Next, how long do you need relief? As Michael said, it depends really on the circumstances and on the type of case. But because there's the practice of having a review date, then that you might find that it depends. And then, as Michael said, it's really important to have as generous a provision for liberty to apply as you can have. Two questions left unanswered, or only partially answered by the Supreme Court in Wolverhampton, were to do with cost capping and the cross undertaking as to damages. And as to the first, the court left undecided whether it was even possible for a costs capping order to be made that would protect defendants' potential cost exposure if they were to actively contest the proceedings. So that's all to play for on that front. And as far as the cross undertaking as to damages, in Wolverhampton, that was a public authority case, and the Supreme Court said, well, in general, public authorities are unlikely to be required to give one, but that there may be exceptional circumstances in which that might be the case. But conversely, if your client's a normal commercial operator, the rationale for requiring that cross undertaking would seem to be much higher. And then there's the question of whether to have a return date. As Michael said, this is optional, but some judges may want it. And I think the more likely it is that actual named defendants are going to turn up and want to say things about it, the more likely that a judge is going to want to have that hearing. And then finally, you've got your order, everyone's exhausted, but you're happy, but work's not over, you've still got to serve it. It's important to have thought about this before you get into it, because the risk is that you get the order premised on being able to serve in certain ways, only to find out that those ways are not possible. For example, if you said you're going to be advertising it in the local newspaper, and it turns out that the newspaper flat out refuses to advertise it. So it's important to be realistic about what can be done. As a general guideline, I think if you've used the method to give notice of the hearing before, it's almost certainly going to be reasonable to use that same method afterwards. But it may well be that you want to take a much more thorough approach to serving the notice of the order so that you forestall any objections from potential defendants. So that's all I had to say on the procedural side. If Michael and Jennifer want to add anything, I'm very happy to.
Can I ask a question about committal? Because you're obviously not personally serving it on anybody. So how do you get that dealt with in this first order, that you can commit them for breach of the order, or do you have to deal with that when you're committing them?
I think you have to deal with it later because we need to rely on somebody having breached the order first. So that tends to be at the next stage when you've managed to find someone climbing that crane or riding that tractor, whatever floats their boat, and then you bring proceedings to commitment on that basis. I mean, even though they're advertising their exploits online on social media, it's incredibly difficult to get hold of these people. I mean, in fact, a lot of them are internationally based. One of the people in Spitbank was from the US, who just came over to do a lot of filming. So yeah, it's lots more to talk about, but I think we've run out of time. So thank you.